My esteemed colleague, Justice Suryakant, and my colleagues present in the audience, Shri Kapil Sibal, the President of Supreme Court Bar Association, Ms. Rachna Srivastav, Vice President of the Supreme Court Bar Association, Shri Vikrant Yadav, the Secretary of the Supreme Court Bar Association, the other office bearers and members, Executive Committee members of the SCBA, Pratnya Bagel, the Secretary-elect of the SCBA, the other elected members, if present, the office bearers of SCORA, and the brothers and sisters from the bar. At the outset, I must congratulate Mr. Sibal and his team for coming out with these two very, very important events. Firstly, the book to commemorate the memory of 75 years of the Constitution of India. As all of us know that the Constitution of India came into effect on 26 January 1950, and immediately after 2 days, that is on 28th of January 1950, the Supreme Court of India was established. So therefore, this year marks a historic occasion as we complete 75 years both of the Constitution and the Supreme Court. Over the 7.5 decades, we have witnessed an unbreakable bond between the Constitution and the Supreme Court. While the Supreme Court was itself created by the Constitution and functions under its provisions, including those relating to tenure, retirement age, and the independence of the judiciary, it has in turn served as the foremost shield of the Constitution. In that sense, the 75-year journey of the Supreme Court is inseparable from the journey of the Indian Constitution. There are two sides of the same coin, one giving life and the other ensuring that the life endures with dignity, justice, and liberty. As noted by renowned constitutional historian Granville Austin, the provisions related to the judiciary were crafted with idealism by the members of the Constituent Assembly, with the hope that the judiciary would act as a guardian of the people's rights. Dr. BR Ambedkar had also famously remarked that the right to approach the Supreme Court under Article 32 is the soul and heart of the Constitution, and envisioned that our democracy would evolve beyond just political democracy to also become a social and economic democracy. The Supreme Court thus was given a huge constitutional mandate. In pursuance of this, the Supreme Court of India developed the doctrine of basic structure in its landmark judgment of 13 judges in the Kesavananda Bharati to safeguard the foundational features of our Constitution. Over the years, it has played a pivotal role in expanding the scope of fundamental rights, articulated by giving a broad and progressive interpretation to the phrase right to life under Article 21. This has led to the recognition of various essential rights such as right to privacy, right to dignity, right to justice, right to food, right to shelter, right to potable water, right to pollution-free environment, and so on. The court has also remained responsive to the evolving needs of society, adjudicating on complex issues relating to information technology, arbitration, and electoral processes. Importantly, it has opened its doors to the most marginalized through public interest litigations. In numerous cases, even a letter from an ordinary citizen has been treated as a writ petition, leading to protection of their rights. I must also acknowledge that the Supreme Court has shown the courage and humility to admit its own errors in the Constitution interpretation. Over the years, several judgments have been overturned through subsequent decisions, reflecting the country's willingness to engage in course correction as and when necessary. An example of this could be in the case of Justice K.S. Puttaswamy versus Union of India, that the right to privacy is a fundamental right under the Constitution. In doing so, the court expressly acknowledged that its earlier decision in ADM Jabalpur, which upheld the suspension of fundamental rights during emergency, was a historic mistake. While the legal effect of ADM Jabalpur had already been nullified through constitutional amendments, the Supreme Court's explicit admission of error stands as a powerful affirmation of judicial conscience. It reflects the court's evolving commitment to justice and its ability to self-correct in the pursuit of constitutional truth. However, as we reflect on the 75 years journey of the Supreme Court, we must remember that this journey is not solely about judges. It is equally about the lawyers who have shaped constitutional discourse through their arguments, ideas, and advocacy. The courtroom has been enriched by the presence of both the bar and the bench. Today, as we release the book on 75 years of Supreme Court of India, I extend my sincere appreciation and congratulations to everyone involved in its creation. It is now our collective responsibility to ensure that the stories of the court and of justice itself reach the people of this country, and we are not confined only to the legal fraternity. While we were reading the book in the launch, I was happy to note the names of the authors. The list contains mainly young, energetic, and very brilliant lawyers who have contributed to this great work. I must congratulate all those who have graciously contributed. I also extend my heartfelt congratulations to the Supreme Court Bar Association for raising rupees 50 crores towards the group Medicare health insurance for its members. Mr. Kapil Sibal has given all the details in his speech. Undoubtedly, this is a remarkable achievement that reflects deep concern for the welfare of the legal community. When a young law graduate enters a profession and begins their journey as a lawyer, they often encounter numerous challenges, from securing mentorship to establishing a stable practice. The path is anything but easy. Financial uncertainty, irregular working hours, and the pressure of navigating the profession without a guaranteed income are just a few of the hurdles faced by young lawyers. The legal profession is demanding, often involving long, unpredictable hours and little to no more time off. Added to this is the emotional and mental strain of working in an environment where outcomes are uncertain and the pressures of finding and retaining clients is constant. In such circumstances, a health crisis can be devastating, not just physically and emotionally, but financially as well. Providing group health insurance, therefore, not just a welfare measure, it is a vital support system. It offers lawyers a degree of financial security and peace of mind in times of medical need. The SCBA's efforts in collecting this substantial fund is truly commendable and demonstrates a commitment to improving the quality of life for members of the bar. I think it's a parting gift by Mr. Sibal and his team to the Supreme Court Bar Association. I hope this becomes a model for bar associations across the country. After all, a strong bar is the foundation of an independent judiciary. I also take this opportunity to urge bar associations across the country to explore ways of raising dedicated funds to provide fixed financial support or stipends to young law graduates who enter the legal profession without any financial safety net. For many bright and capable law graduates, especially those from economically weaker backgrounds or first-generation professionals, the early years in the legal profession can be daunting. Unlike other professions, where entry-level positions come with assured salaries, young lawyers often begin their career without any income, despite working long hours and contributing meaningfully to the work of their seniors. The absence of financial support can deter talented individuals from continuing in the profession or force them to abandon it together. This is where the role of a senior advocate and the bar associations become critical. It is both a professional duty and a normal responsibility of seniors to mentor juniors not only in terms of knowledge and skill, but also by providing them the dignity of fair remuneration, even if modest. I strongly encourage all bar associations to institutionalize such support mechanisms and set a national example. The future of the legal professions depends on how we treat and nurture our youngest members today. Let us work collectively to ensure that no aspiring lawyer is denied the opportunity to serve justice simply because they couldn't afford to stay in the profession. I once again congratulate Mr. Sibal and his team for the two events and thank everyone for giving me an opportunity to be with you. Thank you very much.
Thank you, Madan.